throughout my time here, my family has been repetitively denied. I understand Travis Bloom is an idiot. I understand that. Fully understand that. He holds a good heart.
Fabricating fictitious government you ever seen.
My little brother used to run to mother and say, "Mom, BB hit me." BB was my sister. He used to say, "BB hit me." Mom would say, "Well, my lovely young man, where are the marks to prove such?" Well, my mom, show me the marks. He could not show any marks. Mother would say, "I can't tell where the marks are." True story.
And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
Said that.
Everybody has. Everybody has. What do you say? Everybody has. Oh. Uh, What the heck? My like is grayed out. Okay. It's probably a YouTube. Try to restart YouTube again. Good morning, good evening, good afternoon, wherever you are, whoever you are, and what, if any, you have might been is today. And welcome to a small update in the Karen Reed case. 2 new motions have been filed today. One motion is a reply to Karen Reed's motion to destroy inadvertently produced communication. That's from the House defendants. I call them the House defendants plus because it's a lot of people. I'm not going to mention everyone by name. And the other one is a reply from Karen Reed. But there is an Exhibit 1 attached to that reply that I don't think I have ever seen before. Because in that, we get a little glimpse into what will be potentially Karen Reed's allegations in this case against the House defendants, which I find very interesting. It's a balmy 29 degrees today. Do you think SPF 30 will be okay? It's 31 degrees here, and we have a snowstorm. Hey, Alice G. And Laurie Wallace. Hey, Swissmas. Yeah, I changed my intro because people were always complaining about the music, so I did an intro kind of like my outro with just nothing. Bev's inverted morals and rulings. You missed my birthday because you were sick. I didn't get my celebratory birthday sonate. Well, I can't wish you a happy birthday because it's not your birthday, and as you know, because Danish is superior to every other thing in the world, we find it unlucky to wish people happy birthday if it's not their birthday. So you'll have to hang around for another year. I'm finally caught alive on my day off. Perfect timing. Hey, Laura. Sorry, Ginger. You love my new intro. That's good. Danish Will is the best place. It's right next to Dutch Will. By the way, not to make any promises, but I'm hoping to get up and do a night show tonight because I want to be on the dating game. Come back tonight to figure out what I mean about that one. Do you have a traditional Geburtstagskartoffeln? We don't get potatoes for our birthday. Hey, growth and renewal. The music was great. Having back the old man and his mother-in-law is also great. Good thing, underdog. Big market tease. Well, I have been told that I have potential to finally get into the dating game. I just need new friends. So come back tonight to figure out how I am finally gonna lose my virginity. God, I don't know what a birthday potato. It's Germany. Take anything they say with a grain of salt. You can also put salt on your potato. Make it taste better. But that's for the late night stream. This is for the daytime stream. Oh, sorry, this one. Because this is plaintiff's opposition to defendant's motion in order for order requiring plaintiff's counsel to destroy inadvertently produced communications. This is a long way to say we're not going to comply. We want to keep her emails. Plaintiffs respectfully submit this memorandum of law in opposition to Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication and strenuously dispute the allegations set forth therein. Reed has presented no valid basis to claim impropriety on the part of plaintiff's counsel with respect to the contested email communication. Reed possesses the burden of proving that the email communication in question is protected by attorney-client privilege, and that such privilege was probably preserved. Plaintiffs contend that any applicable privilege was relinquished when Ms. Reed responded to opposing counsel, because Reed and her team failed to adequately mitigate the clear and avoidable risk of inadvertently disclosing confidential communication. It sounds very, very nefarious what Ms. Reed has done. It'll be cleared when you hear the Reed side's answer. This is a lot of words to make this sound like the Reeds have done, or the Reed team has done something very, very suspecting. Hey, Sarah. In addition, even if privilege is deemed to apply, plaintiffs are entitled to retain and utilize the email communication for impeachment purposes should Ms. Reed provide testimony inconsistent with a prior statement. Laura Reicher has been a member for 18 months. You're my longest YouTube relationship. Love you, man. Oh, thank you so much, Laura. You're so sweet. Can you call me handsome? Because I really want to be called handsome. Relevant background. During a status conference on November 21st, the parties convened pursuant to Rule 9C at the direction of this court regarding plaintiff's contention that defendant Reed failed to provide a proper response to plaintiff's interrogatory, seeking the factual basis supporting Reed's third-party culprit defense as required under the rules of discovery. That will also be mentioned in that exhibit number 1. Actually, this is boilerplate, a lot of yammering. It's the spoiler. It's the second I'm reading that you want to stick around for. Thank you, Gina. Thank you. Now someone has said it to me. On December 15th, plaintiff filed a motion to compel further answers to interrogatories from defendant Reed together with Reed's opposition and plaintiff's reply brief. The same day, plaintiff's counsel served Reed's team of attorneys via email with the motion to compel Rule 9A filings, including plaintiff's reply brief. The following day, on December 16th, Reed's counsel responded to plaintiff's email denying the allegation of plaintiff's reply brief and seeking immediate clarification regarding the statement that Reed and her team not only have leaked evidence that now appears inconsistent with the under oath answer signed by Ms. Reed, but also has stated publicly that she has evidence to suggest John O'Keefe was killed inside the house. Unbeknownst to plaintiffs, Reed's counsel apparently blind copied Ms. Reed to the subject email chain before sending the response. Approximately 46 minutes later, Ms. Reed replied to all email participants with factual allegations that are relevant to the aforementioned motion to compel filings and the subject matter of the email chain. Plaintiff's counsel read the email response before recognizing that it may have been sent inadvertently and prior to receiving any notice from defense counsel regarding the same. The content of Ms. Reed's email response was inconsistent with her previous under oath positions in the interrogatory that the subject of plaintiff's motion to compel. Plaintiff will provide the court with a copy of the subject email response for in-camera review on the court's request. Congratulations, Tina, if it's your son's 33rd birthday. Did you have him when you were 5? Hey, Hyacinth. Hey, Nefarious. Nefarious. We tell you you are handsome all the time. What the fuck? Side eyes, you better stay up tonight. The next day, on December 17th, this court issued an order addressing the parties' discovery motion with a request that the parties attempt to narrow areas of disagreement. With respect to plaintiff's motion to compel, the court noted that Ms. Reed's counsel is requested to suggest to the court how to reconcile the position. There is nothing further for the court to compel. With the information in the 4th, 5th, and 6th paragraph on paper, we don't have that motion. On or about December 24th, at the request of defense counsel, plaintiffs agreed to hold their motion to compel in abeyance and to serve Reed with supplemental interrogatory. And down to read it. Plaintiff's interrogatory number 2, state all facts forming the basis for your claim that plaintiff's damages arising from death of John O'Keefe was caused by acts or omissions of third parties for whom Ms. Reed is not responsible, as set forth in affidavit defense number 2 in your answers to the plaintiff's complaint. So this is just to try and figure out what is the claims that Ms. Reed has made about John's passing. Again, stick around. Exhibit 1 will have that allegation or what she claims has happened. Thank you so much, Laura Reicher. Me and my twins are sending you a virtual motorboat. Enjoy. I hope you know what that means. Well, oh my. Oh my. Thank you so much, Laura Reicher, for Super Chat and a motorboat. Oh. Thank you so much. Rephrase to specifically articulate all facts forming the basis for affirmative defense number 2 to which Ms. Reed would respond as required by Superior Court Rule 30A. Plaintiffs agreed to withdraw their motion to compel if Ms. Reed provide an acceptable response to the supplementary interrogatory. That's a hard word. Argument. Defendants read implication that plaintiff's counsel has failed to fulfill their obligations under the applicable rules of professional conduct and case law with respect to Ms. Reed's email response has no merit. Plaintiff's counsel has not disseminated, leaked, or otherwise acted unethically in any way with respect to the subject email. Despite Ms. Reed's contention, plaintiff's counsel is under no obligation to destroy the communication at the direction of defense counsel or to affirmatively seek court intervention, whereas Ms. Reed has the burden of proving that the content of her email response was privileged and that she neither intentionally nor unintentionally waived any such privilege at the time of her reply. Furthermore, even if this court finds that Ms. Reed did not waive any privilege, plaintiffs are permitted to retain and to use the subject communication to impeach Ms. Reed in the event she provides under oath statements inconsistent with her statements in the email. That's why boys and girls, hopefully multiple of both sexes here today. Always make sure to check if it's the right person when you hit reply all, because it can end up in the wrong hands. That is what this seems like. Bevs, just hang out for the reply. That's not as long as this one. But it is a lot of word salad just to say she sent us an email with some statements in that we're going to use to impeach her on the stand if she changes her statement. But they have to do the legalese. They have to write all these words because, hey, why else go to law school and charge people $500 an hour to represent them? Oh, and we have someone who is coming in to try and derail this. Welcome, Chop Cup, the first troll of the day. One in chat to say hi to Chop Cup, the new troll. Never seen that troll before. Welcome, sir. Or madam. Defendant Reed waived any privilege with respect to the subject matter of her email response. In order to show that a communication is protected by the attorney-client privilege, the party attempting to assert that privilege must demonstrate 1. The communication were received from a client during the course of the client's search for legal advice from an attorney in his or her capacity as such. The communications were made in confidence, and 3. The privilege as to these communications has not been waived. In the matter of recognizing of electric mutual liability, INS Co. Limited, 425 Massachusetts 419-421, 1997. And cases cited. Because the attorney-client privilege often deprives the court of relevant evidence, it is strictly construed, and it is the client's burden to establish any application to a particular communication. Carpenter v. Mass, Institute of Technology, 19 Mass L. Rep. 339, citing Emilico, Supra 425 Mass at 421. The existence of the privilege and applicability of any exceptions to the privilege is a question of facts for the judge. Purcell versus District Attorney of the Suffolk County District. Here, unlike the typical scenario involving an attorney accidentally production of confidential material, Ms. Reed herself choose to share her opinions on the legal issue that was the subject of the email chain when she responded to the group. Regardless of whether Ms. Reed's email response were inadvertent, this court should find that Ms. Reed waived privilege due to her failure to take reasonable precautions to prevent the disclosure of privileged communication. The SJC held that the modern trend has moved toward a principle that the privileged status of communication or document is not lost when an attorney or client takes reasonable precautions to ensure confidentiality. But, for example, a privileged communication is nonetheless overheard. The Emilico, also Mass R. Civ P26, governing mistake production of privileged material and discovery, Mass G. Evidence, under Emilico, similar standard applies outside context of discovery. In support of her motion, defendant relies exclusively on the trial court decision in Charm v. Korn, Lexis, in which the judge fabricant held that a client's accidental transmission of a reply-all email communication to opposing counsel did not lose its privilege. While plaintiffs concede that the general circumstances in Charm is analogous to the present dispute, defendant Reed and her legal team conveniently disregard the clear message from Judge Fabricant, warning future litigants of this preventable risk taken by Reed and her counsel here in finding the questions is close. Judge Fabricant cautioned, Cohn's counsel practice of sending him a BCC of emails to opposing counsel with a CC to co-counsel gave rise to a foreseeable risk that Cohn would respond exactly as he did. In sending his response, Cohn would have known what he was responding to, but nevertheless failed to take careful note of the list of addresses to which he directed his reply. On the other hand, a client who seeks to preserve the privilege has a responsibility to be careful, particularly when using a means of communication that poses known and obvious risks. Lawyers should advise clients to be careful and should avoid practices that exaggerate risk. Here it appears that both Cohn and his counsel was less vigilant than they might have been. That's why you should use Signal to communicate with your client and not a mass email. And yes, trolls don't like daylight, so just leave them out in the daylight and they'll go away, because trolls are only getting into people's chats because they want to feel like someone likes them. They are sad, pathetic, small people who really hope that they could just get someone to feel like they do. Look at a Plevin who now, with his sickness, still spends every single day to try and litigate a case that will never, ever be litigated again. Just leave the trolls alone. Make fun of them, smile at them. Nothing they hate more than people not engaging in their absolute asinine delusions that they know the truth. So just leave the trolls alone. With Plevin, you can always say, hey, Plevin, what fake account is this, when he's on one of his fake accounts? But leave the trolls alone. That's the best thing you can do with them. They and others should take note. Reply, all is risky, so is BCC. Further clearness may compel a finding of waiver. That's from Charm 2010. Here, the precautions taken by Reed and her team to ensure confidentiality of communication were careless, not reasonable, in all likelihood by her own direction and or by recommendation of counsel. Ms. Reed has been blind copied on all email communications with opposing counsel since the outset of this lawsuit. As cautioned by Judge Fabricant, this practice exaggerates the known and obvious risk of broadcasting privileged communication to opposing counsel. Plaintiffs do not suggest that Ms. Reed should be kept in the dark concerning development in the case. However, the foreseeable risk which occurred here should have been easily avoided. For example, defense counsel could have simply forwarded the email communication with opposing counsel to Ms. Reed's attention. CMCLE Inc. Managing Client Relationship. The attorney-client privilege and confidentiality, Massachusetts BBO lawyer Joseph S. Berman, Esquire. When a lawyer includes the clients on emails with opposing counsel, the client replies to all, and the other counsel sees the message. An argument could be made that the privilege is now waived for all purposes. Under the circumstances here, including but not limited to Judge Fabricant's warning to further litigants, this court should find that Ms. Reed waived any privilege with respect to the subject matter of a December 16th email communication. See Texaco, Puerto Rico, Incorporated versus Department of Consumer Affairs. Waiver of attorney-client privilege premised on inadvertently disclosure will be deemed to encompass all other such communications on the same subject. Even if Ms. Reed did not waive privilege, plaintiffs are entitled to use the subject email for impeachment purposes. Even if this court determines that Ms. Reed's email communication was inadvertently and that she took such precautions sufficient to preserve privilege, the plaintiffs are entitled to retain and to use the subject communication to impeach Ms. Reed in the event she testifies or answers under oath inconsistent with her statements in the email. In Wigger Works LLC versus Skanska, the court held that while a party's inadvertently disclosure of a privileged communication did not amount to a waiver under the circumstances, such findings did not preclude use of the communication by opposing counsel in the future to assess credibility. Judge Kaplan reasoned that the issue is a little like the bell that cannot be unrung. No witness ought to testify in a manner that is inconsistent with the information communicated in the email. As with statements suppressed because they were obtained in violation of a defendant's constitutional right, they may still be used to assess a defendant's credibility if he testifies at trial in contradiction of those suppressed statements. Citing Commonwealth v. Monkey. Similarly, in Myra Incorporated versus O'Brien, the court held that an inadvertently disclosed privilege letter could still be used for impeachment purposes under certain conditions. Judge Gantz noted that while this court has found that the inadvertent disclosure by Myra's Mira's attorney did not waive Mira's attorney-client privilege. It does not intend by this ruling to require O'Brien's attorney to sit quietly if Curtin or another authorized representative of Mira were to testify falsely at trial, citing Harris v. New York. Judge Grants further stated to permit the trial judge to resolve this controversy promptly and accurate, this court shall permit O'Brien's attorney to retain the privileged letter that was inadvertently disclosed as long as access is limited only to those attorneys who had already read it. This court shall also permit Curtin to be deposed concerning the purpose and meaning of this privileged letter, providing this portion of the deposition shall be closed to all but necessary attorneys and this portion of the transcript shall be sealed. A lot of words that we have to read. I'm going to need a baker's recap on this. All of this is just Karen Reed responded. She hit respond all. And because she was BCC'd into an email chain where the House defendants' lawyers were on it as well, they claim that she waived her lawyer-client privilege because she should have known that it would go to them. Karen Reed have said, you should destroy this communication, and now they are telling the judge, no, we don't want to do that. At least give us the right to keep this email where something is stated in. We don't know quite yet what it is, but we can then impeach her if she says the sky was blue, and they can hold up the email and say, but you claimed the sky was green. It's to impeach her in a future interrogation of her or when she gets to testify. That's all it is. It's just, she sent an email back. We believe there's information we can use to impeach her trustworthiness in court. That's why the court should allow us to use this email. So here, when they say Reed, they mean it's actually her and not just Team Reed. No, this is, a client can waive their privilege status with their attorney. They can say, I don't give a fuck. You can, I don't care. I will tell the House defendants everything. Just send them all our communication. I waive my rights to privilege with my lawyer. She would be an absolute moron if she did that, because then everything would go to the House defendants and they would have all their privileged communication. But you can't do that. You can also accidentally waive your lawyer-client privilege by doing stuff like this, by accidentally hit reply all, and it goes to the opposite side, because they can then read, hey guys, we were talking about, I don't know, we were talking about, should we say that John died in the yard or should we say John died in the garage? I think it would be a better thing to say that John died in the garage. And then she goes on the stand and she says, my belief is that John got out of the car, fell and hit his head on the fire post. They can then take it out and say, hey, we have your communication here where you claim that John died in the garage. So which one is the truth? Because you are allowed to impeach people on prior statements, especially if they don't align with what's said. Kind of like what Alan Jackson did with Carrie Roberts and made her admit that she had lied in a previous testimony. So this is all what this is about. We have a document that we believe has some goodies in it. So we don't want to destroy it, because when we get to trial, we want to hold this piece of paper up in front of the jury and said, well, on December 16th, you said the sky was gray, and now you're claiming it was blue. We can't trust you, can we? So this is what this is about. Have she waived her right to privileged communication with her attorneys? If she testifies, she will testify in a civil matter. All I hear from their lawyers is blah, 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 yammer, yammer, yammer. But again, lawyers have to blah, 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 yammer, 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 because they have to put in precedents. What has happened before? the court has made a ruling that backs our position. Then Karen Reid's team will make a reply and saying, we have blah, 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 that confirms our position. And then the judge will sit there and say, what's heaviest, a pound of lead or a pound of feather? That's why you have to put in all of this BS from previous cases to show the judge there is a way that we believe that you can get us to our goal. And then the opposite side will say, well, we have this that believes that you can't reach that goal because you take the cases that align with your position. And that's typical normal fashion. Normally, they don't take such long paragraphs out of the supporting rulings. They will normally just take out like five lines, and then they will do ... and then reach the conclusion of Madison v. Marbury, blah, 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 whatever it could be. They seem that they really want to fill out 11 pages on this one. But again, that could be their way of communicating. When you read a better motion, he has more his text and then less of supporting text. This one seems like we don't have that much, so we're going to stack it with a lot of precedents. So the judge will see it and say, oh, okay, I have to rule in favor of the House defendants plus. But if this investigation is ongoing, a living, breathing thing, the stated facts could have been true at the time, but with more info coming to light, new beliefs are logical with more data. Enforcing intellectual convo. Yes, but there's always a but. Mine is pretty big, and I'm sitting on it. If she has made a factual statement, if she has said, John O'Keefe died in the basement, and she then goes to trial and she says, well, John O'Keefe died in the garage, they can impeach her with that and say, but you claimed earlier, and then she can say, yeah, well, new information was made available to me. That's why I've changed my position. And they can then say, well, so when you made this allegation that these people were the one who killed John O'Keefe, you made it on some other evidence that you now no longer believe is true. It's all to put her in the worst light in front of a jury possible. That's how lawyers play. Which of Karen's lawyers BCC'd her? I don't know if that's that important. I'll just say I had a false memory. Yeah, well, that makes you come off quite not believable. Brother Counsel just said lawyers should never BCC their clients. That's why I said keep your communication with your client over on Signal. You just port your email over there and then you send it on Signal to them. This is, in my opinion, I'm not a lawyer. I am a stupid YouTuber. But this is one of those rookie mistakes that you make where I'm just going to blind copy her into everything. So she has everything. And she, of course, has, and it's way easier than me copying this email, going into Signal and sending it off to her. Whereas if you had done that little precaution, you wouldn't have to sit and file documents about this. We live in a modern world where I think most people, who want to do a little dirty number with a hottie will go to a secure social media site and send it through that one to protect that it doesn't go everywhere if you get a little frisky. But lawyers are still stuck in, I'll just hit BCC. What could the problem be? Well, the problem could be that you then inadvertently waive the right to privileged communication. That's why I think it was really smart that Karen Reid and her team took the communication to Signal. I use Signal a little bit. I'm not a Signal master, but I think you can make groups and everything in there as well. So you assure this is as encrypted as it can be. So far, I haven't heard any cases where Signal's code has been broken. So that is the most secure place to be. And then you keep your emails for the professionals. You don't put your client into them, because not claiming that Karen is, but clients are dumb. Clients don't understand, hey, you can waive your privilege by just hitting reply all. Oh, by hitting reply all, I'm also alerting the other side. So just to mitigate that risk, you tell your client, no matter if it's Karen Reed or it's Turtle Boy or it's Karen Peters, you tell them you never, ever reply to an email, because you don't hit reply all on an email, because it can go to opposite counsel. If you ever are to reply on an email to me or from me or anyone else, have one designated person in the office who will get that email and then alert the rest of them. That will mitigate that risk. Because when it's Karen who does it, the defendant who does it, they can use this as an argument that she had waived her privilege. That's why you don't just reply all to a group text you got. Tell her, if you want to reply to this, you're writing this email address. I will make sure that Alan Jackson gets it, the rest of the lawyers get it. I am your designated answering machine. So everything goes through me, or everything goes into a room on Signal. You will never, ever hit reply all on any emails, because accidents do happen. You always read the email and see who is copied before you reply. Yes, but people don't do that. People just hit reply all because, hey, I got it from my lawyer. And accidents do happen. We are human. And if anything is true about human, is we are flawed as a species. Damn, I accidentally sent text to the wrong people fairly often. I couldn't imagine that being used as ammunition against me. Bevs, that's what happened in court cases. And these lawyers are professional in getting this. And this is why they make this very big speech about how many cases support their position, because they know their lies by their walk. It seems somewhat balanced to me to agree to hold it but not delete until the judge determines whether actual privilege. We will get the read reply in a bit, Eileen. Here, Ms. Reed's choice to respond to the entire email chain and to make factual assertions directly relevant to disputed issues, in this case, whether... Oh, I read that. Requested relief. Wherefore, the foregoing reason, the plaintiffs respectfully request that defendant Reed's motion is denied. Plaintiffs further request that this honorable court, 1, find that defendant Ms. Reed waived privilege with respect to this December 16th email response to this and its subject matter, and 2, permit plaintiff to retain a copy of the subject email for use at trial and to depose Ms. Reed concerning the purpose and meaning of the subject email communication with any such condition as the court deems necessary. The plaintiffs respectfully request a hearing on this matter. Signed by Mark Diller. And everyone, what does Diller mean in Danish? Anyone know what is Diller in Danish? Come on, some of you degenerates knows this. My husband once sent me a dirty joke, something with a dink in a shoe, and he sent it to everyone. My mother, my landlord at the time, everyone. Oh, Nancy. Oh, Nancy. No Swiss miss, it doesn't mean onion. This is where Sue needs to be here, because she's a degenerate. Does that lawyer still works for her? Most likely, it's Karen Reed's mistake. Karen Reed was the one who hit reply all, so it's not her lawyer's mistake. She has been BCC'd on every piece of communication since the case started. So her choosing that day to hit reply all is a Karen Reed mistake. Courtney said it. Can't see it. Oh, it's because I'm on top chat. Oh, I should put it in live chat. Vanilla G knows it. Yes. Side-Eye knows it. Sorry. Sorry. Courtney, you were the first degenerate. J7 is not participating. Well, what's wrong in a little peen talk? Then we have this reply. Reply in support of defendant Karen Reed's motion for order requiring plaintiff's counsel to destroy inadvertently produced communication. Plaintiff's opposition relies on alleged practices by Reed's counsel, which plaintiff made up out of whole cloth. They then argue that these non-existent practices resulted in a waiver of perhaps the most important privilege recognized by Massachusetts law, the attorney-client privilege. Plaintiffs do so in a cynical attempt to abuse a party's honest mistake to seek an illusory litigation advantage, and this specious tactic should not be condoned. Big words. Plaintiffs' alternative argument that they should somehow be allowed to keep defendants inadvertently produced non-waived attorney-client privilege communication for impeachment purposes is equally baseless. On February 2nd, Reed served her answer to second interrogatory and even a cursory comparison of the two documents. The answer and the privileged communication demonstrate that the privileged communication does not provide plaintiffs any additional area for impeachment. So what they are saying is, boo-hoo, you lose. What she said in the email is the same that she said in the answer we sent to you. Plaintiff's assertions are meritless, and the court should reject them all. Reed's email resulted from an accidentally reply all, the one time her counsel blind copied her on an email, which does not come close to meeting the standard of waiver. Oh, so they didn't have a practice of blind copying Reed on every single email. That should count as, well, then it's an honest mistake by Miss Reed. I bet she's used to receive a separate email before with the OG lawyers. Probably that's what they're arguing here. Plaintiffs base the entire waiver argument on their allegations that by on her own direction and or by recommendation of counsel, Ms. Reed has been blind copied on all email communication with opposing counsel since the outset of this lawsuit. Factually, this is simply false, and nothing in the record supports it. In fact, Reed attaches to this reply an affidavit from Reed's counsel confirming that this was a one-time blind copy to Reed and that it is not his practice to include her on emails. However, even without this affidavit, there is nothing in the record that allows plaintiffs to make this unsupported logical leap regarding counsel's practices, nor do they point to anything in support. Instead of seeking to capitalize on a common and understandable human error, which most lawyers, professionals, and other email users has committed at one time or another, plaintiff and their counsel should heed Judge Fabricant's advice, which they conveniently replace with ellipses in their opposition. As a matter of courtesy, and in recognition of their own vulnerability, lawyers should avoid the temptation to seize opportunities arising from inadvertent disclosures, from the same charm V cone that the opposition used. An inadvertently disclosed privileged communication provides plaintiffs no unique area for impeachment. Reed recently served her answer to plaintiff's second interrogatory, which seeks the basis for her affirmative defense that third parties caused Mr. O'Keefe's death. That answer is attached as Exhibit 1, and that's what we all been waiting for. Comparing this answer to the privileged communication demonstrates that there are no areas for impeachment or uniquely to the privileged communication. Said differently, if plaintiffs intend to impeach Reed later, they can simply use the sworn answer. They don't need the privileged communication. To be clear, Reed has no problem with plaintiffs asking her about any of these topics. She only opposes the attempt to use sharp practice to strip her of benefit of attorney-client privilege. Damon M. Seligson. Boom. That's how you answer that. But this is what I found interesting. Because I haven't seen this before. I haven't heard the allegations that are made in Exhibit 1. And I find them quite interesting, to be honest. Answer to plaintiffs Paul O'Keefe's as personal representative of the estate of John Joseph O'Keefe III, first supplemental interrogatories propounded upon defendant Karen Reed. Defendant Karen Reed answers the supplemental interrogatories propounded upon her by plaintiff Paul O'Keefe as follows. Interrogatory number 2. So this are what they want her to talk about. State all facts forming the basis for your claim that plaintiff's damages arising from the death of John O'Keefe III was caused by acts or omission of third parties for whom Ms. Reed is not responsible, as set forth in affirmative defense number 2 in your answer to the plaintiff's complaint. This is what we couldn't hear in the criminal case because Bev wouldn't let it in. And in the second trial, he said, okay, the jury got confused about that whole third-party culprit defense. Let's just stick to the facts. No car ever hit John O'Keefe, which, in my opinion, was the correct way to run the case. Third-party culprit defense got way too wishy-washy, and it got way too hard to understand when Judge Bev didn't allow them to bring in all of their facts. But now Paul O'Keefe has asked, why do you claim someone else killed John O'Keefe? And I think it's quite interesting. Sorry. Answer number 2. Ms. Reed objects to this interrogatory to the extent it seeks information outside of her knowledge and possession. Of course, she can't talk about anything she doesn't know about. Ms. Reed further objects to this interrogatory to the extent it seeks information subject to the attorney-client privilege or work product doctrine. Again, boilerplate. Ms. Reed also objects to this interrogatory as premature because discovery is just beginning in the case and she has not yet received full production from the Massachusetts State Police or Norfolk District Attorney's Office, among others, which may contain additional evidence or information relevant to her answer. Therefore, Ms. Reed reserves the right to amend or supplement this answer as discovery proceeds, subject to or without waiving these obligations, Ms. Reed states. So, like we talked about before, what could they use this email from? Because, hey, what is it? This is where she is now. Maybe they find the smoking gun. So if they want to impeach her with, hey, but you said at December 16th, before you got all this additional information, before someone came forward and told you they saw someone on the grassy knoll, so why should we believe you now? So that's why they are getting all of that in there, just to say, hey, we might change our tactic coming down the line. So far, this is what we have today. This is what we believe today. So this is what she gave them on February 2nd. I was acquitted by a jury of all criminal charges relating to the death of John O'Keefe III after a full and public trial that exposed pervasive investigative misconduct and corruption. I did not cause and am not responsible for Mr. O'Keefe's death. I did not strike Mr. O'Keefe with my car. Mr. O'Keefe's wounds are inconsistent with being hit by a vehicle and consistent with being in a physical altercation and attacked by a dog. So far, one in chat if we all agree. The credible evidence indicates that he was beaten inside the home of 34 Fairview in Canton, Massachusetts on the night of January 28, 29, and he died as a result. Below, I describe certain information and facts of which I am currently aware. However, I believe there are additional facts and additional evidence that I do not possess, which will further support the referenced affirmative defense. To date, I've not engaged expert for a trial in this matter, and therefore this response do not take into consideration their opinions. So again, this is very early on. I have a rough sketch of what I believe happened, but I will get more evidence the closer we get to trial. Additionally, at trial, I will rely on my attorneys and experts to explain the evidence, what it means, and how it indicates who is responsible for Mr. O'Keefe's death. Other than knowing I did not hit John with my vehicle and that it was not me who killed Mr. O'Keefe, I am presenting my knowledge solely as a layperson who observed evidence obtained and presented in connection with 2 criminal trials against me. During stupid English, my criminal trial, multiple witnesses provided testimony supporting this affirmative defense. First, my counsel engaged a private investigator who took photographs of a cemented ridge curb just inside the garage, and the pathology expert my counsel again engaged opined that Mr. O'Keefe's head wound came from a ridged ledge. This is something we haven't heard before. Remember, we have seen that picture of the paint spilled in the garage. So she has an expert and an investigator who claims that John O'Keefe's head wound is consistent with hitting a curbed ridge in the garage, as Miss Diva would say it. We know they tried to get some of this in. It wasn't allowed in. So this is new information in my opinion. Also, that she has a pathology expert, that's the word I was trying to say, pathology expert who will opine that this is consistent with the head wound that John O'Keefe had. The big problem with John O'Keefe's head wound that I think most of us all had was it was so inconsistent with being from an impact on the ground. Remember that this is kind of what it looked like. It was a straight jagged line across the back of his head, a very straight edge, which seems inconsistent with hitting a flat object. A flat object could still split the skull if there's enough force behind. We have all tried this where we will hit our head against something and it'll bust open. But this had a very distinct linear edge to the wound. And they now have an expert in pathology who will opine that this wound is consistent with hitting a cement ridge or something like that ridge they had in the garage. To me, this is newer information. I thought it was either the ledge in the garage or the ledge in the family room on the floor from the fireplace, enforcing intellectual conversation. I have consistently believed that it was the safety nooks on the bench Because if you have ever seen one of those, if you go to the gym, and I know you ladies do a lot of upper body work because you want to be swole, they have this catch that's kind of like a hook that you put the bar into. And I've always said, if it happened in the garage, that would be my guess of what, because it's roughly the same distance as his wound in the back of his head. But we kind of went from the basement to the garage. Looked like a Nike swoop. I never saw the swoop in it. I think it was just because this part was a little bit more flapped, because I always saw it as a very distinct line. And one thing about nature doesn't make straight lines. I don't know if you have ever observed that, but nature can't make straight lines. Nature isn't perfect. And that's why a crushing impact that splits your skull open and makes a perfect straight line, there would have to have been a rock with a straight head in the ground, on the ground, to make this very distinct, roughly, I think it was about 2 inches long, split in his cranium. That's why I always said this fits perfectly with the bar you rest your chest chest press, your barbell. It fits, in my opinion, it fits perfect when you rack it in that one. That was, to me, the perfect explanation, because I believed that they might have gone into the basement. But they now claim they have a pathology expert who will opine that the wound is consistent with a ridged ledge. J-hook mark on his head next to the wound looked like the hook end of the fire poker tools that you have set next to the fireplace. I remember people talking about that. There was like an indentation more than a wound. I do want boulder shoulders. I get there someday. Overhead pressing and a lot of shrugs. Was that Jay big enough for a fire poker? No, it wasn't. I would think it was more something that was on the ground when he hit his head, and it made an impression. It wasn't big enough to be a fire poker. First trial, I thought weight plate with raised riding. Yes, a lot of people thought dumbbell, but I don't know how many dumbbells have. I know you can get the octagonal ones, but they're normally rounded in the end, so it would be really hard to do that to a skull, because dumbbells are made to, if you kind of drop them on you, that they don't make sharp impacts. They'll just crush your bone. They won't rip your skin. Except I had a guy at my gym who did like overhead presses and dropped a dumbbell in he split his forehead really, really nice. South Boston Kev, I'm not going to start over. Dr. Labosada said a rich, pebbly type surface, which would be very consistent with a cement, concrete, small curb in a garage. And we have all seen that picture with the red paint. And I love that the foreskins and the rest of the aunties are sitting there saying, hey, yo, they're claiming it's blood. No one ever claimed that it's blood that you can see in the picture. It's paint, but you can pour paint on biological material to hide the biological material. Don't try this at home. Samantha Benigno believes he went in through the breezeway entrance to the living room. Well, Sarah, me, Samantha, Turtle Boy, Brother Council, Declarer, we are all just guessing. We don't know what happened. And it seems like with the testimony or with the answer that Karen Reed believed it happened in the garage. So I don't think he went into the living room. Thought the J was the metal clasp on the back of his cap. You know, the bit that straps threads through to adjust how tight it is. Could be. Could be. Further, 3 separate doctors testified over the course of the 2 criminal trials that Mr. O'Keefe's arm wounds were consistent with an animal attack. And my understanding is that the owners of the house of 34 Fairview Road in Canton, Brian and Nicole Albert, testified in the first criminal trial that the Albert's dog Chloe never went out into the front yard. Therefore, I believe Mr. O'Keefe was inside with Chloe. Chloe, who is now in Vermont, identifying as a 10-pound Chihuahua. Next, Ian Whiffen, the Commonwealth's own witness, confirmed Mr. O'Keefe's Apple Health data showed 3 flights of stairs were climbed after 12:20 a.m. The Apple Health data also shows Mr. O'Keefe taking enough steps to get inside the house of 34 Fairview Road in Canton. Mr. Whiffen further presented evidence that Mr. O'Keefe's phone's battery temperature stayed flat for 3 hours in the middle of the night at just under 50 degrees, which is too warm to have been outside in the snow, and then plummeted just before I found his body at 6 a.m. This was one of those experts I wish the defense have had a better reply to. Because this idiot who, I don't know how cold my freezer was, I just chucked the phone into the freezer. That's not a scientific study. That should have never been allowed in. This is just as dumb as the Murdoch trial where I was just throwing a phone around in the living room or in my office. You can't replicate that experiment. That's why the ARCA guys so painstakingly filmed everything, because you have to be able to send it to the opposing counsel, and they can then replicate it and say, well, your science is bunk, or no, your science is good. And I feel that was one of those experts that you just needed to bitch slap harder than, Loophole almost had me convinced it happened in the driveway. I think the first time I read anything from Karen Reed, she said, I saw him at the front door, going up to the front door. That's the last time I saw him. So I didn't think it happened in the driveway. She's going to win. She just have to. Money, this is a civil matter. It's way different because it's not beyond a reasonable doubt. It's just 50.000000001% guilt, and she can be found guilty. So she needs to really have her ducks in a row for this one. Nefarious, agreed, Baker, a freezer isn't the same. It's not scientifically enough. No, you need to have, so you can monitor the environment, the entire experiment. It's the same when he claimed, well, if you're driving around those hills, it'll simulate 3 flights of stairs. No one has ever been able to replicate that outcome, which means it's not scientific. You have to film it, say, okay, see this, I'm driving, I'm holding it like this, and then I'm sitting here looking at the vase saying, hey, this is Bella's mom's house, turn left. And that will give you, because his testimony about how the roads would have led to 3 flights of stairs crawled because of the elevation in Canton, using his own elevation maps, I did the math, and he would actually have ended up, if it was true what his testimony was, that you have to travel a certain distance up or down for it to register, he would have ended up with actually descending 2 flights of stairs. Because he goes up a little bit and then all the way down to Fairview, it's a slight decline. So his own math was absolutely bonkers. A stupid Dane could sit here with an elevation map. Yes, I learned to read elevation maps when I was in the military, and could tell if what you claim is the way to figure this one out, you would have John O'Keefe's phone descending 2 flights of stairs after ascending 1 flight of stairs. So all of this should have, on the face of it, been thrown out as absolutely unreplicable science. Only in Canton was that allowed in as expert testimony. Enforcing, if it's the lip on the floor of the fireplace, it's not. They claim it's in the garage. They can go in and get a print of it. They can, but again, they claim it's in the garage. Aiden did that drive with the same model phone. Yes, those streets are flat. Well, everything seems flat, but on an elevation map, you could tell that there was slight elevations and de-elevations. I don't know what that's called. But I was looking at the height map of that area where he claimed that because he went up this amount of percentages in such a long time, that would count as a stair. But that wasn't true because it was descending after, and for the most of the way, it would be a descending ride. So he would actually go into a basement, not walk up flights of stairs. We have to remember the McAlberts are liars. Just because they claim they were in the kitchen doesn't mean they were. Last time blinds were open, trial 2, Jen then says closed and distance from text. Kirk, this is why I am so worried about people putting blind faith into this trial. This is the one that's finally going to get justice for John O'Keefe. These people had no qualms lying to the FBI. Do you think they will have any qualms lying on an affidavit or in a deposition? Absolutely not. Unless, and I mean unless, they get someone to flip. There will, and I'm sorry to rain on everyone's parade, there will never be justice for John O'Keefe. The best we can hope is they will have monetary damages. But there will never be justice for John O'Keefe because these people are natural-born liars. They have lied to the Federal Bureau of Investigation, and they didn't blink. They admitted in court they lied to the FBI. They admitted in court that they lied to Bev. Harry Robert changed her statements from trial 1 to trial 2. She will lie about whatever Jen tells her to lie about. That's the sad truth. And that is not defamatory because we know she lied in court. She admitted she lied in court. She lied to a grand jury. This case, if these people had been truthful, would never have been brought against Karen Read because there would have been no reasonable ground to put this case on if not Carrie Roberts had confirmed that Jen McCabe was told to search Poe's like to die in the cold at 6:13, 6:23, whatever it was. That was a clear lie, and it just shows you there will never be justice for John O'Keefe. And sadly, maybe it's because they are blinded by sadness. Maybe it's because they don't want to figure it out. But it seems like the O'Keefe family are not that interested in finding the real killers. I'm sorry. Whiffen didn't even try to replicate things. I think Bev's a little behind. With the same model and software that Jen had on her phone, nor did he have nor did he have all of the metadata or the file to compare for alerted days confirmation bias. Yes, and he clearly stated, I'm just here to prove because that's another thing. They all claim Celebrite. Celebrite proved that she didn't Google Poe's long to die in the cold because it couldn't have happened at 2:27. That's not what he testified about. He said, we can't say it was at 2:27. It could have been before. It could have been after. There's no timestamp in the middle of the night or in the morning that we find credible. Funny enough, they used exactly the same timestamps to find Brian Walsh guilty. But that's a different case, so of course facts doesn't matter. But what Ian Whiffen said and what the foreskins and all the idiots often forget to tell you is he said, I can't tell you when Jen McCabe did that search. It could have been before, it could have been after. If it could have been before and it could have been after, it could have been at 2:27. A lot of people missed that part of his testimony. He never said he didn't do it at 2:27. He made a lot of, well, she opened and there was a close, and what he said was, I can't tell you when the hose long to die in the cold was searched. I can tell you when something was open and something was closed, and a lot of big words, hashtags, hash values, health data. But what really ultimately was his only testimony worth anything was, I cannot tell you she didn't do it at 2:27 because I can't tell you when she did it. She could have done it before, she could have done it after. That means she could have done it at 2:27. All Sellbrite did, go in and delete all the timestamps in the database. For this one case only, I have heard no other cases ever where timestamps is not the timestamps. Interesting, they never ever brought in any of Karen's actual phone data, only the text. Her phone would show what time she searched for music in her car whilst outside Fairview and what emails read. Perks, they'll probably say, well, that wasn't important. She was calling him a pervert. We know it's that. I also understand that a stain on Mr. O'Keefe's sneaker had DNA from 5 male contributors. That was another one. I understand there were 5 males inside Fairview 34 in the early mornings of January 29th. And there's that no one saw Mr. O'Keefe outside before 6 a.m., including Lockie Loughran, a snowplow driver in the area during the relevant time period. In addition to these facts, the individuals inside the house of 34 Fairview in the early morning of January 29 also took actions that strongly suggest wrongdoing, including tampering with, destroying, fabricating, and manipulating evidence, all in concerted effort to direct blame towards me. At the same time, the individuals and entities who had the responsibility to fully investigate the circumstances of Mr. O'Keefe's death, including the MSP, the CPD, and the Norfolk District Attorney's Office and their respective officers, troopers, and employees, failed to adhere to their duties and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house after Mr. O'Keefe's body was discovered. They did so because of, among other things, personal connections between the lead MSP investigator, Michael Proctor, and individuals within that house. Proctor's and other investigators' adherent bias, the occupants' connection to various local, state, and federal law enforcement agencies, the individuals in the house that night engaged in a concerted effort to direct the investigators' attention away from themselves and toward me instead. Accordingly, based on the information and evidence available to me, I believe that one or more of the occupants of the house of 34 Fairview Road, Canton, during the early mornings hours of January 29th, caused Mr. O'Keefe's death. However, as a result of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured, and I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. What I do know, without any doubt, is that I played no part in causing, participating in, or contributing to his death in any way. Signed under the pains of penalty of perjury on the 1st of February 26 by Karen Reed. So, this was the 2 motions that dropped today. The pants on the back pocket had male DNA. there was so much DNA on John O'Keefe. I always jokingly said maybe he was at the toilet at the bar because of the male DNA on his shoes. We men are known not to be that accurate while we are doing our business. But how will you ever find out whose DNA it is if you don't get DNA from the people in the house? Remember, they only took DNA from 2 people to exclude them from the comparison. They didn't get Bryce. They didn't get Bry Juniors. They didn't get Collins. The only person was only to remove suspicion because they're cops, so they shouldn't be in it. You let your pants touch the floor in the bathroom. No, he had 5 men's DNA on his shoes. By the way, Hank didn't ask Ian about his credentials. He has a high school degree and 3-week training. Take basically nothing to work for Cellbrite. He uses unverified studies on personal websites during testimony. He was admitted as an expert in Cellbrite. Again, if she has lost, I would have lost my mind and tried to appeal on that one. But the defense said okay. So the defense admitted him as an expert. They spent all this money on Aperture and Cellbrite, but didn't use any money to test the DNA. I wonder why. Why, oh why? First of all, you are now a seasoned police officer. Who arrives outside of a house where there's a dead body on the front lawn. First of all, you allow a family member of the occupants of the house to go up and ring the doorbell to get them out of there. You let her stay in there. I can't remember, is it 7 or 10 minutes that Jen McCabe is in the house, goes downstairs with Brian, who is putting his clothes on. Remember, he had a hot session of lovemaking with Coco that night. 7 and 10 minutes later, Lank enters the house, where he takes a quick talk to Bry in the foyer and says, fucking weird, we just found a dead guy out in your front yard. No, what? That sounds weird. Yeah, Jen told me it was her lifelong best friend, Mr. John O'Keefe, a good colleague of mine. Remember, they all loved him so much now if you listen to the foreskins. But in that house, you had Brian Sr., you had Brian Jr., you had a body that looked like it had gone 11 rounds with Tyson. You never think these people are in any way suspects in this case. No way at all. Because you saw a shoe was knocked off a foot, and then you knew instinctively that this is a car strike. You then get to learn that you have had Colon. Who were the other 2 males who were in the house? It was, well, you learned that at that night where Karen Reed, who you believe it was, says she dropped off John O'Keefe outside. You have these people in the house. You know these people were at the house that night. And not one single one of them makes you think, hey, maybe there's something fishy going on here. This guy looks like he's beat up. He's outside. He's very lightly dressed for someone who would be out in the snow. And the position, that's another thing that doesn't make sense to me. You have John O'Keefe all the way over here at the end of the front lawn. This is the only access way to the house. It had started to lightly snow, but not that much. Why would you drive forward and drop him off over here? I could get that you might have sat out here and said, hey, I want to go in and keep drinking. And she said, no, I don't want to keep drinking. Let me just run in and I'll be back in 5 minutes and we can go home. I could get that. And then she might have moved up when the Nagels arrived. To me, okay, I buy that explanation because, hey, this is the only entryway to the house. So when Julie Nagel has to come out and talk to her brother, why would I block this area? So he had to park over here. No one would have driven up here and said, well, fuck you, woman, I want to go in drinking. And then gotten out of the car all the way over here. Remember, Jen McCabe said she saw the car parked out here for a while. If John was hell-bent of going into the... It's the opposite way. Hell-bent on going into drinking at the house, why would he keep sitting while she moved forward? And no one saw anyone in the car at that time. Why wouldn't he have gotten out in the driveway? It makes no logical sense that she would have driven 18 feet forward and dropped him off there, or however much it is. Because why would he run over the lawn to get into the house? The only logical thing would be stopping outside, as she said she did, him running up the driveway, going into the house somewhere, because she didn't see what door he went in through. She said, I saw him by the house. That's the last time I saw him. Then the Nagels arrive. You pull forward because you are nice to them, and you're waiting, and you're saying, what the hell is he doing? I've been sitting out here for an hour now, man. Come on. I said I want to go home. My stomach hurts. I have my problems. I need to go home and spend some time on the think tank. It makes no sense to find the body at the end of the lawn. Again, even if they had an argument and she said, well, fuck off, get out then. Let's use that hypothesis. They are arguing in the car. The Nagels come up behind them. No one sees John. They are arguing. Karen is angry. We know she's angry. Bella's mom, he wants to go in, party. So she moves up because she's still considerate, because everyone knows when I'm really angry, I'm thinking a lot about the person behind me. So I move my car up, and we are still fighting. They drive past us after a couple of minutes. No one still sees John anywhere, nowhere to be seen by the people who drove past us. We are yelling, screaming a lot, except Ryan Nagel said she was placed with her hands at 10 and 2. But they're still fighting a lot in the car. Remember that. They must be fighting, and he's trying to convince her and say, hey, babe, it's just one beer. Come on now. You can borrow their toilet. Well, I don't like to go on other people's toilet when I have stomach problems. It's kind of embarrassing. No, come on, they'll be fine. Come on, let's party. I'm ready to rock. And he then gets out of the car where she accelerates, not fast, because the telemetrics didn't say she was just gunning it down the road. She moved forward, slams it in reverse, and then backs up. Why, if he was so hell-bent of going into the house, was he just standing there? Oh, she drove off. I'm just going to stand here in my very light clothes in a beginning snowstorm with the wind going through my T-shirt. Why wouldn't he already be jogging up the road to get into the house, or jogging over the the front lawn. Again, if you just apply logic to it, this story doesn't fit anything. I bet some of that DNA on John's clothes matched a few people that was in that house. You will never know because you don't have that DNA. Driving in reverse is hard enough sober. I couldn't drive 34 miles per hour in reverse. Aiden can't do it. 0 photographs of it being on brown paper and DNA of not the I don't know. I missed something, Kirks. Hey, Alice. Wie geht's dir heute? The fact no one saw him on the lawn meant Karen hit him with her SUV. Yeah, which would be impossible because it wasn't snowing so much that it could cover John O'Keefe. John O'Keefe was quite a big man. And it wasn't a heavy snowfall till that morning. Everyone who drove that night must have seen John O'Keefe on the front lawn until at least, I think the snow picks up around 4:35 a.m. That's when the snow starts coming down. That could have accumulated with the blowing of wind and everything. But until that time, everyone who left the house after Karen Reed hit John O'Keefe and killed him, if that's their theory, must have seen them if they drove in the same direction. Everyone coming out of the front door, in my opinion, who didn't come out while talking to someone or something, who just came out, would have seen what, that's a weird black thing out there. I don't know how many of you have been in the military. When you learn how to do surveillance at night, you're always told to keep your eyes moving. Because if you look at something, if I'm saying, okay, I'm just going to look over here, you will go totally blind. Unless there's a big movement, you won't see it. If someone sneaks up slowly, they can get really close to you before you ever see them. But if you pan your head from side to side, new things, your subconscious will pick up, oh, that wasn't there before. So anyone coming out would have had that, what the hell is that big pile over there? And it's in the middle of the lawn. It would be a perfectly flat area with a little bit of snow on it. And then you had a big dark thing laying on the grass. And no one who left the house that night saw anything. No one. Every car that backed out with their tail to the right and drove forward would have illuminated John O'Keefe's body. No matter if Jen McCabe was looking backwards and talking about how funny and on she is because she makes peanut butter jelly sandwiches in her car, no one can believe that the man who was driving the car didn't see John O'Keefe. They never asked that question. Well, I was looking at something else. Your eyes would pick it up. We have seen the videos where they have reenacted it. All of this is bullshit. Kiwi Green, compasses are cool, okay. After turning left, Fairview, it's on a decline. They descended, de-elevated approximately 32 feet. It continued after 32 too. Sorry, I'm late. But that's what I'm in agreement with. They descended 3 flights of stairs, but they went up 1, so he would have ended up being 2 flights of stairs lower than his where he was. That's the math I did with the elevation map. It's too small for gym equipment. Sometimes I wish I looked at chat all the time because I don't know what it is about. They act like the lawn was so massive and the snow so deep that they couldn't possibly see anything. And that's just a lie because we have seen how it's 2 cars deep. A car is around 3 meters, 4 meters. So it's not that deep. And again, just coming out because they said everyone went out through the front door. That's the door we used. That's in the middle of the house. So when you open that lights would spill out, and you would walk out, and you wouldn't notice in your peripheral there's something big laying over there next to the flagpole. I have a little more faith in humans than they apparently do in Canton. My eyes works in this direction. Are Americans only able to watch anything that happens in this direction? It makes no sense. Also, peripheral vision is better at bright and dark perception. Exactly, and that's why in the military you're told to do this, because your subconscious will pick up, oh, that wasn't there before. When you don't, if you stare right at it, you won't see it. But if you turn your head, you will notice that's not supposed to be there. You have more snow on your J7 video than they had that night. Yes. And thank you so much, J7, for my new hat, because that was perfect to go out and shovel the snows. We are primed to recognize and react to danger. It's why we can jump at non-threatening things. So it's hard to believe your brain wouldn't detect a large human shape, aka potential danger. Big dark things in the night makes you go, ooh. That's just how it is. If you go into a wooded area and you just see a big dark thing right next to the road, you will automatically go, oh, that could be dangerous. Because you can't discern, what is this? Is this a bush? Is this a predator? On our basics, we are animals. We are not that evolved from when we were out on the savannah. Back then, if we saw a big black thing in the middle of the night, it could be a lion. Lions don't hunt at night. Shut up. So you would be careful if you saw something like that. It's human nature. You will notice it. You will see that shape looks weird. That's not supposed to be there. It's your subconscious. That's why I'm afraid of snakes, but I'm not afraid of spiders. Apparently, somewhere down the line, my genes figured out, hey, snakes are dangerous. Spiders are fine. Other people will still have that big fear of spiders because it's bred through generations. Because why should I, who live in a country where we have two types of snake, where one of them has the same venomous attack as a bee, why should I be deadly afraid of snakes? They are no threat to me. They haven't been a threat to me or my family in the last 2,000 years. But still, if I see a snake, I'm deadly afraid. That's because it's bred into you from when we crawled down from the trees and started running around on the savannah in Africa. That's the same basic instincts that we all have that'll give those warning signs. Why do we get we call them ant tits when you get or goose skin or whatever you call it. Why do we have hair standing up when we see something that, why are we afraid of this? Why do I get anxious around this? It's because your subconscious is screaming at you, something's wrong, danger, Will Robinson, danger. Every streamer needs a J7. At least everyone who wants to be handsome and decked out for a snowstorm. Everyone left their peripheral vision at the house that night. When you hear it's raining men, you just get yeah. Laurie Anhole, I like snakes and spiders. Yeah, we call it ant tits when you get we call it goose skin as well. You know, when you get the little prickly, when your hairs on your arms stands up, it's either ant tits or goose pimples. I think you call it goose pimples. We call that ant tits. There wasn't enough snow for a snowbank. The majority didn't fall until after John was found. Exactly. Goosebumps. I don't know why. Got the wheel of spinny. Go out, come back in. You have the circle of death. I'm live. Everything seems fine, so it's on your end. always try and before you tell me that you have the circle of spinning, go out of the program, come back in. Most likely it's YouTube's connection to your phone. I think it happened to a lot of us. It's a YouTube I have excellent connection, so that's all I can say. Always remember, people, when you get the circle of death, the first thing you should do, just refresh. If you keep having that, close the window, open the window again. Those are the two most likely reasons why you have the circle of death. It's not, and no matter how much circle of death you have, I can't fix it anyway. I went weird for a few seconds. I have been weird my entire life. But it's a YouTube to you signal. It's not a me to YouTube signal problem. But yes, but instead of refreshing, it's easier and more fun to blame you. Exactly. Just tell the streamer who can't do anything about it, hey, I have a problem. Okay. Same if you fart, refresh, and open window. Yes. But everyone, these were the two motions. This is the first time I have read in writing that Karen Reed has an expert who will testify something to the fact that John O'Keefe's head wound is consistent with hitting an elevated edge. And another expert who testifies about the raised curb in the garage that potentially could have made this made these marks in his head. I will jump off now. It's 8:30 at night. I'm gonna go watch the rest of JFK, the movie. I started yesterday. Great movie. And I will be back at 11:30 tonight. And where sadly I have learned that I am unlikable. And I need new friends, then I will be dateable. That's why it's called The Dating Game Tonight. Thank you all so much for watching along with me. Go out there and have a great day and touch all the things on the way out. I'll giggle like a schoolgirl if you touch the like button.
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't word
It's
your
my
questions
third,
carefully.
but I'm still better at it than you. You are
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.